About the Regulating Act. This is British decided to regulate the East India Company. Regulate the East India Company and demarcated the political plus administrative function of the company. Laid foundation for the central administration in India. Governor of Bengal is known as the Governor General of Bengal, and Governor of Bengal was designed as the Governor General of Bengal. Governor of Bombay and Madras subordinate to the Governor of the Bengal. Executive Council of the 4 members was formed for the Governor General. 4 member Executive Council was formed. Officers were prohibited from the private trade. No private trade of the officer. First Governor General was known as the Warren Hastings, and Supreme Court was established at Calcutta. Now next act was 1784. So demarcated the political and commercial function of the company. Commercial affairs was managed by the Court of Director, and political affairs managed by the Board of Control. Board of Control and Court of Director. Board of Control can be supervise the operation of government and revenue. British government got complete control over the company affair. So in the company affair, there was a complete control. Next was Charter Act 1833. The Governor General of Bengal, designated as the Governor General of India. Bombay and Madras Presidency lost their legislative power. Bombay and Madras lost the power. Governor General got complete control over civil and military. Civil and military was the complete control. Law member was added as a 4th member to the Governor General. So law member was also added as a 4th member of the Governor General. Law Commission was constituted, and there was a Law Commission, and law made from these acts were named as Act. The last Indian company has to end the commercial activity, so commercial activity was ended, and the first Governor General of the India was the Warren Bentinck, William Bentinck, and this act tried but failed to introduce open competition. So open competition they wanted to be introduced, but that were not be introduced. So Governor General of Bengal was designed as the Governor General of India. Bombay Madras Presidency lost their legislative power. Governor General got the complete control over the civil and military. Law member were added. Law Commission constituted. Law made from this act were named as the Act. And East India Company has to end the commercial activities. First Governor General was William Bentinck, and this act tried but failed to introduce open competition. Now 1853 Act. The separate the governor was appointed as the Bengal. It was separated the governor, extended the company rule. So company rule were extended. Separate the legislative and executive function of the Governor General Council. So legislative plus executive power was separated. Open competition was introduced. Open competition. Number of the court director were reduced from 24 to 18. Court of director were reduced, and legislature become the separate entity. Central Legislative Council was formed, and its functions are mini parliament. Central Legislative Council, and it is a mini parliament, and 6 legislative member was Madras, Bombay, Bengal, and the Agra were given here. Governor of India Act 1858. East India Company were abolished. Court of Director and the Board of Control were abolished. 1858. Governor General of India was designed as the Viceroy of India. Now its name was the Viceroy of India, an officer of Secretary of India. Secretary of India. A 15-member council was formed for the advisory body. Act was a good government of India. It was a good government in the India, and Secretary of India was formed, and Viceroy of India was made. Now, first Viceroy was the Lord Canning. Lord Canning. एंड डायरेक्ट रिप्रेजेंटेशन ऑफ द ब्रिटिश क्राउन में अब इनका डायरेक्ट रिप्रेजेंटेशन हो गया. ठीक है. नाउ नेक्स्ट वाज द काउंसिल एक्ट. इंडियन काउंसिल एक्ट 1861. लेजिस्लेटिव पावर ऑफ बॉम्बे एंड मद्रास वाज रीस्टोर्ड. वाइसरॉय कैन अपॉइंट इंडियन एज ए नॉन ऑफिशियल मेंबर. सो वाइसरॉय वाज एज ए नॉन ऑफिशियल मेंबर. And new legislative council was established at the Bengal, then Northwest 1860 and Punjab. Viceroy was empowered to make the rules and order. Viceroy can issue the ordinance also. So ordinance issue can be do. No need for support from the legislative council. And Lord Canning nominated 3 Indian as a legislative council. Maharaja of the Patiala, Raja of the Benares and Sir Dinkar Rao. Portfolio system were added. Portfolio system were started in this act. Indian Council Act 1892. Increase the number of the non-official council. Legislative member can discuss the budget and ask the question. Nominated system was non-official member was Viceroy can appoint the non-official member and Governor can appoint the non-official member from Provincial Council. Now the Council Act 1990. The Central Legislative Council was expanded 16 to 60. Member of the in Provincial Assembly was not contest. Member in the council were empowered to ask the supplementary question they can ask. Provincial Legislative Council was allowed the non-official majority. System of communal representation. So communal representation was introduced here for the separate electorate system for the Muslims electorate system, and that was Lord Minto was introduced this system. And this act was also Maudley Minto reform. So Maudley was the Secretary of State and the Minto was the Viceroy of India. Satyendranath Sinha was the first Indian to join the Viceroy Executive Council. Satyendranath Sinha was the first for the join the Viceroy Council. Governor of India Act 1919. It's known the Montagu-Chelmsford. The Montagu was the secretary and the Chelmsford was the Viceroy of India. British declared Act of Introduction of Responsible Government. And provincial subjects were divided into reserve and transferable subject. First was reserve subject, then transferable subject. And central provincial legislation was authority make the law. And system was known as the diarchy. It was known as the diarchy, and there was the reserve and transferable subject Viceroy, and Montagu was the secretary and the Chelmsford was Viceroy. And provincial subjects were divided into reserve and transferable. Central provincial legislative and diarchy was introduced. Provincial budget were separated from central budget, so budget was also separated. High Commissioner of India was set up in the London. And Central Legislative Council was replaced by the bicameral. It was a bicameral legislation, and High Commissioner was set up, and Direct Legislative Council was replaced by bicameral. Direct election was introduced. Franchise was limited. Affluent people of the property tax and education. Separate electorate were introduced for the Sikh, Anglo-Indian and Indian Christian and European. Upper house was the Council of State and lower was Legislative Assembly. Now next was the commission. Now there was a Simon Commission. Simon Commission, it is a statutory commission. There was a 7 members constituted to report the impact of the new Constitution of India. New Constitution of India. Chairman was the John Simon, 1930, and the abolition of the diarchy. So diarchy was the abolished continuation of the communal electorate, and there was a communal electorate, and establishment of the Federation of the British India in the province, and responsible government was in the province. It is a responsible government, and all member in the commission was a British. This all were a British member, and the commission was appointed 2 years before the schedule. So that was the John Simon, 1930, abolition of the diarchy, continuation of communal electorate, establishment of Federation of the Indian and province, responsible government, and all members in the commission were British. Commission was appointed 2 years before the schedule. Now the communal award. This communal award was the representation of the minorities. There was a MacDonald. MacDonald was a PM. Separate electorate were extended to the scheduled caste, and the Gandhiji first led to the Pune Pact, also there Pune Pact, and this Hindus have the joint electorate and reserve seats for the scheduled caste also there. So communal award was announced by the Ramsay MacDonald, and the separate electorate were extended to the scheduled caste. Minorities were represented. Government of India Act 1935. So this act was the bicameral legislation first of all in the Bombay, Bengal, Madras, Assam, Bihar and United Province. Extended franchise to the 10% of the people. Extended the separate electorate for scheduled caste, laborer and the women. Composition of the act was the 10 schedule and 321 section. Provision established the RBI, abolished the Council of the India. Provision established of the Federal Public Service Commission, Provincial Public Service Commission, Joint Public Service Commission. Federation was not formed. Provision of All India Federation, Federal List, Provincial List and Concurrent List. Introduction of the responsible government. Responsible government, and the governor should act according to the advice of minister. 1937. In 1947, the partition of India. Emperor of India, Office of Viceroy plus Office of Secretary of the State. Governor General was given power to assent to the bill. Governor General can assent to the bill, and discontinued the appointments of member of civil service. Ended British rule in India. India became a sovereign state and provinced by Governance of India by Government of India Act. Granted freedom to the princely state and empowered the Constituent Assembly as a sovereign body to adopt their own constitution. Next one was Constitutional Assembly. So Constituent Assembly, the first proposer of the constitution was the M.N. Roy. In 1934, the Indian National Congress demanded Constituent Assembly. 1935. Demand was accepted by 1940, that was a August offer. Cripps' proposal was rejected due to the territorial ambitions of Muslim League. Cabinet Mission Plan was accepted this, and 9 December 1946, Muslim League boycotted this. Legislative body and the constituent body, that was Mavlankar was the prepared the constitution for the Free India, G.V. Mavlankar, and the Rajendra Prasad was to make the ordinary laws. Constituent Assembly was the functions till 26 November 1949. There was 11 sessions and 2 years, 11 months, 18 days. Final session took place 24 January 1950. Continue to Provisional Parliament 26 January. Temporary President was Sachidanand Sinha and permanent was Rajendra Prasad. Vice President was the S.C. Mukherjee and Constant Advisor was B.N. Rao. Composition of the Constituent Assembly. There was a strength of 389 members, and in that 296 was British and the 93 was princely state. 292 was the provinces and 4 was the chief commissionery. The seats were allotted in the proportion of their population. Elections were conducted by the proportional representation by means of single transferable vote. Representatives of princely state were nominated by their respective hand of princely state. Seats were decided among the three principal communities, that was the general, Muslim and Sikh. Committee of the Constituent Assembly, that was the major committee was the Union Power Committee, then Constitutional Committee, Jawaharlal Nehru, State Committee, Jawaharlal Nehru, Drafting Committee, Ambedkar, Rule Committee, Rajendra Prasad, Steering Committee was the Rajendra Prasad, and the Provincial Constituent Committee, that was the Patel, and Advisory Committee to the Fundamental Right Patel, Fundamental Right Subcommittee J.B. Kripalani, Fundamental Rights Subcommittee Kripalani, Minority Committee S.C. Mukherjee, Order of Business Committee K.M. Munshi, House Committee Pattadi Sitaramaiah, Flag Committee Rajendra Prasad, Finance Staff Rajendra Prasad, Committee on the Chief Commissioner Provinces Pattabi Sitaramaiah. Original Constitution, there was a preamble and 395 article, 22 part and 8 schedule. Presently it is 25 part, 448 articles and 12 schedules. Government of India Act, Public Service Commission, Emergency Provision, Office of Governor, Judiciary and Federal Function. Australian Constitution, we taken the current list, joint sitting of the Houses and freedom of trade. British Constitution, parliamentary form of government, bicameral, cabinet system, legislative procedure, single citizenship, rule of law and parliamentary privileges. Canadian Constitution, we taken the federal form of the government, residuary power in the center, advisory jurisdiction of Supreme Court. French Constitution, we taken the republic, liberty, equality and fraternity. Irish Constitution, DPSP, procedure of the president election and the nomination of Rajya Sabha. Japanese procedure established by law. South African election procedure of the Rajya Sabha, procedure for the amendment. Soviet Constitution, fundamental duties, social, economic and political justice. US Constitution, fundamental rights and independent judiciary, impeachment, procedure of president, procedure for removal of vice president, procedure for removal of Supreme Court and High Court and judicial review. Weimar Constitution, that was suspension of the fundamental right during the emergency. So that was the Weimar Constitution. So that's why it's a bag of borrowing. Preamble. Preamble, literally the preface of the Constitution, and that was the objective resolution. It was put by the Jawaharlal Nehru. Preamble is a non-justifiable and element of preamble cannot be altered. As per the Supreme Court, preamble is part of Constitution and there was added the word socialist, secular and the integrity. So socialist, secular and integrity was added by the 42 amendment. Socialist, secular and integrity. Element of the preamble. India as an independent state means sovereignty, sovereign. Then socialist was added in the 42 amendment 1976. India followed democratic socialism. Indian socialism is blend of Marx and the Gandhi. Marx plus Gandhi. Now the 42 amendment we added the secular also. No national religion, all religion have the same status. Justice, social, political and economic, equal voice, equal opportunity and equal access to political affairs. Equality is civil equality, political equality, and economic equality. Liberty, thought, expression, belief, faith, and worship. And fraternity is about the brotherhood and the friendship and the mutual support. And ensure this single citizenship, we have the Article 1 where we put single citizenship, and Article 51 and A where we put the fundamental duties. Indian follow the representative parliamentary democracy, and executive is responsible to the legislature. Universal adult franchise, independent judiciary, rule of law, and periodic election. Political sovereignty vested in the people. Head of the state is president. All public offices are opened into public without any class discrimination. Next is the part 1. The part 1 was India, that is Bharat, shall be a union of state. So Article 1. Article 2 is about territory of the state, union territory, territory acquired by the India and specified in the first schedule. So this all was in the Article 1. Now we are discussing about Article 2. Uniting two or more state, separating, unite karna, separating two or more state, or uniting the territory also. So new state increase the area, decrease the area, alter the area, or alter the name also. And procedure of the bill. Bill is sent to the concerned state to express its view. Opinion of the state is not binding. It is not binding. Okay. And bill is introduced in the parliament by the recommendation of the president, and bill can introduce either house of parliament, and finally the bill is passed by the simple majority. These bills are passed by the simple majority always. Okay. Now the commission of the state formation. If we want to go to form a state, so first is the Dar Commission. This Dar Commission was for the linguistic province of 1948 to find the possibility to reorganize the state in linguistic basis. Second is the JVP Commission. JVP is a linguistic province 1948 to find the possibility reorganize the state in linguistic basis. That was Jawaharlal Nehru, Vallabhbhai Patel, and Pattabhi Sitaramaiah. Three person was there. This report was rejected by the formation. Now the Fazal Ali Commission was there. This Fazal Ali Commission was for the State Reorganization Act 1953. Fazal Ali, K.M. Panikkar and the Kunjuru. Fazal Ali, Panikkar and Kunjuru, and accepted the state formation on the linguistic basis and suggested the abolition of the four parts like A, B, and C and D, and three centrally administered territory. Now next was citizenship. Article 5. Born in territory, either his parents was born in territory or ordinary residents of India. Article 6. He is either of his parents was any grandparents born in India 19 July and 1948. And a person not citizen of India if migrated to the Pakistan after first day of the March 1947. Article 7. Article 8. Person ordinary residents like OCI, NRI, and PIO. Article 9. A person not a citizen if he will acquire the citizenship of any another country. Every person is citizen of India. Provision of the law made by the Parliament, and Parliament have the power to make the law on the citizenship. Now, Article Acquisition of the Citizenship Act. There was a Citizenship Act 1955. Every person can acquire citizenship by birth of 26 January 1950 before, born on after 1 July 1987, but before recommencement of the Citizenship Act 2003. Born after commencement of Citizenship Act 2003. Both of this. Now citizenship of naturalization is the person not a illegal migrant. The person satisfy the qualification for naturalization in the third schedule. The person has the rendered distinguished service in field of science, philosophy, art, literature, and world peace. Citizenship by descent. By descent, if father of the citizenship of India, if his parents, if he born 1992 either his parents citizen of India, that was by the descent. Citizenship by registration. If person is married to citizen of India resident in the 7 year, they are minor children of the person who are citizen of India. Person is of full age and the capacity, whose parents are registered as a citizen of India and are either of the independent India. Citizenship of India Act 1955, an act to provide citizenship by the birth, either by birth, either by the descent, either by the naturalization, either by the registration, either by the termination, renunciation and the deprivation. 3 was to the terminate. Minor illegal migrant overseas citizens of India, undivided India and the ordinary residents of India. 3 were given. Government of India Act 1935. Now termination of citizenship. If you want to terminate, either you will renounce the citizenship, renunciation or termination or deprivation. Deprivation, when you are taking citizenship of another country. Termination, any person voluntarily acquiring of citizenship of country will cease to be a citizen of India. Central government may by order deprive the citizenship of India. And renunciation means citizen of India of the full age of capacity can renounce. Declaration has to registered by the prescribed authority, and declaration of renunciation is withheld during the war engaging India. Every minor child of the renounced person will also cease to be a citizen of India. Now next is the fundamental right. Part 3rd of the Constitution. The part 12 and 35. There was initially 7 article, now it's 6 article. 31 is given right to property, and 44 amendment 1978 it was removed, and now it is added 300A and part 12. Okay, पार्ट 12 में इसको ऐड कर दिया गया था. और यहाँ पे है 12 डेफिनेशन ऑफ द स्टेट. 13 द लॉ इनकन्सिस्टेंट विद द डेरोगेशन ऑफ फंडामेंटल राइट. 14 to 18 is equality, freedom, then right against exploitation, right to freedom of religion, cultural right, right to the constitutional remedy, and 33 is the modify the part 3rd. 34 right of the during the martial law, and 35 was the legislation to give the effect of part 3rd. Fundamental right. Fundamental rights are not absolute. It is not absolute. Fundamental rights are not permanent. It is not permanent. If suspended during the emergency, in the emergency it will be suspended. And fundamental rights are justifiable. It is justiciable and granted by the Supreme Court also. So aggrieved person can approach to the Supreme Court. People can move to the court for violation. They can amend by the Constitution. State can impose restriction on this also. Now, what is the definition of the state? Government of India or Parliament, they are the state. Government and the legislature. Legislature also part of the state. All local or the other authority within the territory of India is also a state. All local authority under the control of the government of India is also a state. Article 13. Article 13 is a law. Laws include the ordinance. Ordinance means authorizing order, orders, written rules, bylaws, regulations, notification and custom laws. Law inconsistent with the part 3rd is demand to void. Law made by the state which is takes away, abridge away is the part 3rd. Right to equality. So state shall not deny to a person equality before law. Equality before law. And state shall not deny to any person equal protection of law. Article 15. No discrimination. State shall not discriminate against the citizen on ground of religion, race, caste, sex, No citizen shall, on the ground of religion, race, caste, sex, was restricted to access the shops and the wells. Special case state not prohibiting to making special provision for advancement of socially and educationally backward classes. Equal opportunities. No citizen shall, ground of religion, race, caste, birth, is discriminated on employment. State is not prohibited from making special provision for the backward classes, and state cannot impose restriction religious institution regarding the official for same religion. Abolition of untouchability. Untouchability is a offence, and Article 18 was the abolition of the title. Citizen of India shall not accept any title. Foreign national holding office of profit under the Indian government cannot accept any present emoluments, and foreign nation holding office of profit under the Indian government can accept foreign title only after the consent of the President. Now, right to freedom. Right to freedom was all citizens have the right to freedom. Article 19. Article 19 was the speech and expression, assemble together, form association, and freely moving the freely, and reside and settle any part of the territory, and practice any profession. Article 19 D and E can be restricted for the protection of scheduled tribe. D means move freely and E means reside and settle. Right under Article 19G doesn't prevent state from making the law. No person shall be protection conviction of the offences. So Article 20 is again the conviction of offences. Conviction of offences. So this article was convicted for any offence except for violation of law in force at the time of commission of the act charged by offence, subjected to penalty greater than the crime inflicted under law in force at time of commission of offence. No person shall be prosecuted punished for the same offence subject to the penalty greater than crime inflicted under the law in force commission. No person accused of any offence shall be compelled to be the witness against himself. Witness against himself or the same punishment will never be there. No person accused of the shall be compelled witness against himself. Now protection of life and personal liberty, it was 21. No person shall be deprived of life and personal liberty. Article 21A, right to education. The state shall provide the free and compulsory education 6 to 14 years. 86 Constitutional Amendment 2002. Right to children for the compulsory education was 2009. Protection against arrest and detention of a person, that was Article 22. It was the arrest and detention. No person who is arrested shall be deprived of without the informed, denied the right to the consult. Prisoner shall be produced in the court within the period of the 24 hours and detained in custody beyond the set period without the authority is registered. Article 22 and 22(2) is the enemy alliance, and enemy alliance will be there. The imprisonment of a person to prevent him from the committing further offence. No law can authorize preventive detention for a period of longer than 3 months, and in order to extend the period of preventive detention longer than 3 months, the advisory body will consisting of high court judges and detained the person shall be given the opportunity to defend himself. So preventive detention is also given in the Article 22. Arrest in the 3 month, and after 3 months the competent authority will be consult in that for arrest and detention of a detainee. Right against exploitation. So Article 23 prohibition of the trafficking. The human trafficking is very in that beggary and similar form of forced labor is also there. So prohibition employment of the children in the factory and trafficking. 14 years of the age employed work in the factory and mine engaged in the other hazardous employment. Right to freedom of the religion. Article 25 to 28. 25 is freedom of the conscience, profession and practice. Conscience, profession and practice, and propagation also. All persons are equally entitled to freedom of the conscience. The article does not prevent the state from making law, regulate, restrict the economic, financial, political, secular activity. Article 26 is the religious denomination of the rights to establish the institution, to manage own affairs, to own the acquired the movable and immovable property, to administer the property accordance with the law. Article 27. No person shall be compelled to pay any tax of the promotion of any particular religion. Article 28. No religion instruction shall be provided. Educational institution administered by the state but established under the endowment of the trust shall impart the religious instruction. Education institution recognizing by the state or the relieved aid out of the state fund shall not demand any person to take part in any religious instruction, not demand any person to attend any religious worship without will. If such person is minor, his guardian has to given the consent of the religious worship. Cultural and educational right. The right to conserve the distinct language, script and the culture. So religion, race, caste and language, that was the educational institution is denied. Religion, race, caste and language. The minority have the right to establish and administer education for the religious language. State shall do not discriminate any minority education institution based on the religion language. Minority have the right to establish administer education institution based on the religion and language. And a state shall not discriminate any minority educational for based on the religious and the languages. Article 15. Right against the discrimination. Right to equality, right to freedom, right contest election, right of language, script and the culture. Language, script and the culture. Right to admission into the educational institution and right to establish the administer educational institution. The remedy, constitutional remedy, there is a habeas corpus, mandamus, prohibition, quo warranto and certiorari. To right to move the Supreme Court for appropriate proceeding, enforcement of the right. The Supreme Court can issue direction or the orders or writ for enforcement of the right. Parliament may by law empower the court to exercise all any power exercisable by Supreme Court. The right guaranteed by the Article 32 shall not be suspended except otherwise provided for this Constitution. Article 37 to 51 DPSP. Article 37, it is not enforceable by the court. Article 38, state shall strive to promote the welfare of the people promoting the social order. State shall strive to minimize the inequality of the facility opportunities. 39. State shall direct the policy that citizen men and women are equally have the right to the adequate mean of livelihood, even distribution and the cultural material resources, operation of economic system, equal pay for equal work, men, women, children being a forced economic necessary to enter the vacation, and children are given opportunity to facilitate develop the healthy manner, provided with freedom and dignity, and protected against the exploitation of the moral material abandonment. Article 39A was the equal justice free legal aid. State shall provide free legal aid by the suitable legislation. Article 40 is for the village panchayat, and state shall organize the panchayat for self-government. Article 41 right to work, education and public assistance. Article 42 just and human condition for the work. Article 43 is state shall endeavor to secure the decent standard of the life and providing the work for all worker and the agriculture industrial. Article 43 a state shall make the provision to secure the participation of the worker and management of the undertaking. Article 44 state shall secure for citizen a uniform civil code. Article 45 provision of the free and compulsory education. Article 46 was the provision of educational for the SC/ST. Article 47 duty of the state to level up the nutritional. 48 to organize the agriculture and animal husbandry. 49 was protection improvement of environment, safeguarding the forest and the wildlife. 50 separate the judiciary from the executive, and 51 promote the international peace and the security, and 49 promote the monuments and the place of object national importance, protection of the monuments. Article 51 there is a promote the international peace, maintain just honorable relationship, foster respect, law and treaty, encourage the settlement of international disputes and arbitration. Article 51A. Article 51A and Part 4 and A, that is about the fundamental duties. These duties are: duty number 1 to abide by the Constitution, respect the ideal. Abide by the Constitution and respect the ideal of the Constitution. To cherish, follow the noble ideals. B is the noble ideals of the Constitution. Noble ideals of the Constitution. C. Uphold, protect the sovereignty, integrity and unity. Unity, integrity and sovereignty. D. To defend the country and render the national service. Defend the country and render the national service. E is to promote the harmony, spirit of common brotherhood. Harmony and common brotherhood. And F to value, preserve the rich heritage. 6 number is value the heritage. And after heritage, 7.1 is improve the natural environment. It is for the natural environment. 8 is to develop the scientific temper. For the scientific temper. 9 is to safeguard the public property and no violence. Safeguard the public property and no violence. 10 is to strive the excellence all sphere. Excellence in the all sphere. So, excellence in the all spheres. And 11 is who is parent and guardian to provide the opportunities. So, guardians are to provide the opportunities to education of the children. The President. President in Article 52, there shall be a President of India. Article 53, the executive power of the President shall be vested in the President and shall be exercised by him either directly or officers subordinate to him accordance with the Constitution. Supreme Court, Defence Force and the Union vested in the President. Article 54, election. Elected member of the Legislative Assembly and elected member of the both House of the Parliament. So, elected member of the Legislative Assembly and both house of the parliament. And process of election, the state are represented uniformity in the elected vote for calculation and the election of the president held by the system of proportional representation by means of single transferable vote and using the secret ballot. Term 5 year and 65 year, whichever is earlier, by writing hand to the address vice president, violation of the constitution and not withholding the expiration of the term and hold office until the successor enter upon the office. Eligibility for the re-election, a person who hold the office is eligible for the re-election. Qualification, like he is a citizen of India, 35 year, election of the House of People. Now a person is not eligible for the election of the hold the office of profit under the government of India, under the government of state or any authority. Exception of the any sitting president, vice president, governor, ministry and the this all. Now 59 condition of the president's office. The president shall not be a member of either house of parliament or the house of legislature, vacate his seat on to the date of which he enter upon the president. The president shall be entitled without payment rent use the official residence, entitled to such emoluments and the allowances as may be determined by the parliament, entitled to the emoluments are the specified by the second schedule, and his oath in the third schedule. The election for the vacancy caused by the expiration of the term shall be compelled the expiry of the term. Election to fill the vacancy of the president may arise due to death, resignation, removal or shall be held within the 6 months from date of occurrence of the vacancy. In the 6th month, the date of occurrence of the vacancy. Article 61 is impeachment of the president. Impeachment of the president. So it is preferred the either house of parliament. Resolution moved after the 1/4, like 14 days before, and writing signed by the 1/4 of the total member. Such resolution has been passed by the majority of not less than 2/3 of the member of the house. President has the right to appear. President has the right to appear and take part in the investigation initiated in either house. Majority of not less than 2/3 of the member will required to remove the president from his office. Vice President. The ex officio chairman of the council of the state. Ex officio chairman of the council of the state. Hold any office of profit. Do not hold any office of profit. Perform the duty of office chairman of the council of the state and enter any salary allowances payable by chairman of council of state acting in the president. Now article 65. It is article 64. If the vacancy in the office of president is due to death, resignation, removal, otherwise vice president shall act as a president for the new president. Vice president shall discharge the president function for absent, illness and cause. Election of the vice president through the electoral college consisting of the member of the both houses. Member of the both houses will go for the election of president by system of the proportional representation of the single transferable vote by voting in the secret ballot. It was for the secret ballot. So vice president shall be not be a member of either house of parliament, not be a member of house of legislative state, and vacate his seat on the date on which enter upon the office of the vice president. A person eligible for the election of vice president if he is a citizen of India, 35 year of the age, and qualified election of the member of the council of the state. A person is not eligible for vice president if under the government of India or under the government of state or local authority he is in office of profit. For exceptional is president, vice president, governor and minister of the other house. Election dispute regarding the election of the vice president are settled from the Supreme Court. The term of the vice president is the 5 years. Vice president may writing underhand and the address to the president resign of the office. Vice President may be removed his office by the resolution of the Council of the State passed by the majority of the House, and such resolution shall be only after the 14 days notice is intention to the move the resolution. So 14-day notice will be there. An election of the till vacancy caused by the expiration of the term office of the Vice President shall be completed before expiration. An election of the bill will be the vacant for the Vice President. Discharge the President function of other contingency. It was in Article 17, and the Parliament by make special provision for discharge the function of the President during the contingency. So what is important in this? First is the Article 66, where it is given that he should be a citizen of India and he has completed the age of 35-year age and he is qualified for the election of the Council of the State, and also given that he should not take any office of profit. In Article 67, the removal of the Vice President is given. So after 5-year term, or a Vice President may be writing under hand to the President, or Vice President may be removed from office. Resolution of the Council of the State is passed in the majority of the member, and resolution shall be moved only after the at least 14 days notice and intention move to the resolution. Now Article 68 is the election to fill the vacancy of the Vice President is completed in expiration. So there is a, like, if he want to remove, then if he has in the death, resignation, and otherwise shall be held soon possible after the occurrence of the vacancy. So after the occurrence of vacancy, the election of the Vice President will become in Article 68. In Article 70, he discharged the President function in the other contingency. If there is any contingency, then he will discharge the function of the President also. The Parliament by make special provision for discharging of the function of the President. That was Article 70. Article 71. This Article 71 is about the dispute arising out the connection with the election of President and Vice President. So it will inquire into the Supreme Court, and decision taken by the Supreme Court is the final. The decision of the Supreme Court is the final one, and act done by him during the tenure shall not be invalidated. So Parliament may by law regulate any matter relating to or connected with the election of President or the Vice President, and vacancy among the member of the Electoral College does not affect the President and Vice President. So there was the Electoral College relating to this for the election. And now we are going to discuss about the Council of Ministers.